computer to change the sound?
No, I don't know. You just have to put mute on yours. Just get it. Just press good.
Okay, so I did. So I have it on mute. So we should be fine.
Yeah, they got it.
It's on mute, so I'm good.
Yes, ma'am.
All right, let me just do one more thing.
Oh, there's something.
I'll have a big one. We'll have a big one.
Guys, I have to remember that there are petitioners and respondents.
I know, I'm not used to writing that.
I've not either. It's been so long since I've been on the civil side.
I still say state.
I do too.
Yeah. We'll see how many times I say
Whenever
it.
you're ready, Judge.
All right, just give me one moment. I'm just limiting access. And just so everyone knows, on the YouTube channel, we've learned we have to limit what people can do because sometimes there's chatter going on. Defense attorneys were upset. They're like, we want to chat like your rulings and stuff so we can be discussing the ruling you just made. And of course, I can't see any of it that's going on. But so I've learned how to stop any chat. Okay. Just 1 second. Okay, we're starting. All right, ASAP, goodbye. All righty, yes, bring them in and everyone just make sure when you're speaking that you're, if you're conferring amongst yourself, make sure those green buttons are off and you have to hold them down.
Okay. Okay, number one. Let's go. Everybody start going. First row. One, two, seven. Yeah. Go ahead, I'm thirsty. And then second row on top. Then, thank you. Number 15, there's the, you start next. Twenty-two at the end. Number 30.
I know. Usually it's been 2 years.
Yeah. Has it really been 2 years?
Like today, I think.
Oh my gosh.
And today is my 7th year with Bear County.
Yeah, you shouldn't tell me.
Lucky number 7.
We're gonna have to have a celebration.
69. That's it.
Thank you. All right, everyone, please be seated. All right, everyone, good morning. Okay, that is so weak. I mean, it's a beautiful day outside. You know, everyone is excited to be here. Good morning. So this is my court reporter, Brenna, just reminded me that this is our first jury trial in 2 years. So you all are our first jury trial in 2 years, and I know you all gonna make it great. So these are a few rules. Number one, Brenna has been with the county, she just told me 7 years, otherwise we would have had great celebration. So she's the court reporter in the court. We actually have an intern court reporter. I always tease everybody and say, talk low and whisper to give her the worst things that could possibly happen, but we're not gonna do that today because it's Brenna's anniversary. So this is what I need from everyone. I need everyone to make sure that you talk loudly so that the petitioners and the respondents can hear you, but most importantly too, so that Brenna can hear you. Because if Brenna doesn't hear you, then it's like it didn't happen because she takes down everything that's being said. My name is Stephanie Boyd. I'm the judge of the 187 District Court. I've already introduced you to Brenna, that's Heidi, and I'm gonna let the respondents and petitioners introduce themselves. So for the petitioners, if you could introduce yourself, please.
Olivia Thayer and Jacqueline Janice.
And for the respondents.
My name is Charles Morgan.
Good morning, Justin Morgan.
And this is JOAQUIN.
So out of the people that have just introduced themselves to you, does anyone recognize or notice or know any of the persons who just introduced themselves? Okay. All right, so this is what's called jury selection. And what's going to end up happening is the petitioners and respondents are going to be asking each of you some questions. Now, this is what I can tell you so that Brenna can hear you. Everybody who's not in the jury box and not on this first row, if you could stand when you have when you're answering a question and speak loudly so she can hear you. So just make sure you do that. Now you do have some cards that cost like $30,000. So we want to make sure that you use them. So if someone says something that you would like to respond to, then raise your card. So let's practice, everybody, if you can raise your card. Okay. And what they'll do is they'll call on you. Or if they say something that you feel like it corresponds to you, just raise your card and then they will speak to you. Now, it's not anyone's intention to embarrass anyone. So if there's something that you don't want to answer in front of all of your best friends, just let us know. The other thing, other than meeting downstairs today and standing in line, do any of you know each other other than just meeting today? Okay, that's all. Usually we have a school teacher whose student is on the panel with them or something. So I see we don't have that. So anyway, I have seen the judicial system in all different countries because I do CLEs in different countries. And people always say that the United States has the best jury system. And the key to having a great jury system in jury trials is, guess what? Jurors. So if we don't have any jurors, we can't have jury trials and the system fails. So I want everyone to think about that when you're listening to the questions and answering them. Now, I expect this jury trial potentially to be completed before Friday or by Friday. Is there anyone here who has some sort of plane tickets And when I say plane tickets, I mean non-refundable. This is a trip of a lifetime. Or some time constraint that you feel as though you won't be able to sit on this panel. All right, number 31, if you could stand up and tell me what your time constraint is, please.
I have plane tickets to go get my son to spring break in Colorado on Friday.
Okay, speak up.
Oh, I'm sorry. On Friday, I have plane tickets to go get my two sons in Colorado for their spring break. And I'm,
Have they been enjoying spring break? Or
well,
they're
their
going?
spring break's next week.
Oh, and you're going to spring
Yeah.
break with them?
I'm going to bring them back.
Okay.
Yeah.
All right, thank you. Anyone else? 37?
I have an appointment with an attorney, a bankruptcy attorney on Friday.
Okay. Anyone else? Number 40?
Pick up my elementary school children by 15 each day. So
Okay. And just so people know, when you have issues where you need to pick up children, we always make accommodations for that. Number 67?
I have to take my mom to doctor on Thursday. Her appointment is 4 o'clock, but I have to pick her up at 6:30.
6:30 a.m.
No, PM.
p.m.
Yes.
So 6:30 p.m. on Thursday, you need to pick her up?
Yes, I need to pick her up and take her to doctor.
Okay, all right, thank you. All right, if anyone has some questions to ask so that you can. All right, anyone else? Number 13?
I don't know if this is an excuse or so, but I'm a physician and I have to cancel like 40 patients today and yesterday, and I have full panel scheduled for Wednesday, Thursday, and Friday.
All right, what type of physician are you?
Primary care.
All right, thank you. All right, so before I turn it over for questioning from the attorneys, I want to remind you all of one thing, and this is a true story. Brenda has heard this story before. So when I graduated from law school, I always wanted to do criminal law. So I was constantly in trial. My friend who now works in Austin, she always did civil law. So we hadn't seen each other, had that much time to spend each other. So she had jury selection. So she comes downtown in Bexar County for jury selection. And I asked her how it's going. We decide to have lunch. And she's like, oh, it's going great. I'm not going to be selected. And so I started laughing. She's like, what's so funny? I'm like, why are you thinking you're not going to be selected? And she said, it's just like when we're in law school, I'm at the back. I'm not saying anything. I'm being quiet. And so I started laughing. And she's like, Stephanie, what's so funny? I'm like, you're so going to get selected. So I don't know why it happens, but when you're quiet, you get selected. So other than raising, and I know all of you want to be on this jury trial, but other than raising a sign above your head and pointing, saying me, the quickest way to be selected is not say anything. So there you go. So I hope that will start conversations. All right. And I see someone in the Cowboys outfit. Their season will be better next time. There's always next season. I'm with the Saints, so that's for me too. All right, so I'm going to turn it over for questioning. Yes.
All right, thank you, Your Honor. Good morning.
Morning.
It's actually pretty good. So my name is JOAQUIN Janice. I was introduced just a little bit ago, and I work with the Special Prosecution Unit out of Huntsville, Texas, and we are here trying this case, assisting the District Attorney's Office here. So this is a unique part of trial because this is the only time that we get to talk to each other. Normally, when you make it on the panel or on the jury, you end up just having to watch us talk. You don't get to actually participate. So I do ask that you take this time to really allow us to get to know you so that we have the best fit for, or best jury for this case. Now, I do want to be upfront. There are rules that prevent me from being able to go into the details of the case. So if you ask me a question, oh, does this case involve X, Y, and Z? I'm going to have to tell you I'm sorry. I'm not allowed to answer that question, but I wanted you to know up front so that you know I'm not trying to hide anything from you whenever we start asking questions. So our goal here today is to find 12 impartial jury members to sit over here, to listen to the evidence, and make a decision based on the evidence. Now, I want to talk to you about a word. When I say impartial, a lot of people think of the word bias. Who here thinks of bias as kind of a negative thing? Just by a show of hands. Okay, thank you. I want to just say we all have biases. We have all grown up with experiences in our life, and we carry those things with us. And you can continue to carry those things with you if you make it on the jury. What we have to do, though, is you don't want your bias to be so strong that it prevents you from listening to the evidence in the case, or that it sways your opinion in a certain way. So you can have biases, that is okay. But what I need to know is how strong is that bias? Does that make sense? So when I'm asking you questions today, that's really what I'm trying to find out. How strong is your bias based on a specific issue? Now, I'm going to give you an example. I promise you this has nothing to do with this case. It is purely a hypothetical, but it's just to get us, our brains start working this morning, okay? So if I told you, and just for the show of cards, if I told you that someone committed a sexual offense at the age of 18, who here believes that that person will do it again? Just, and then hold it up for me. Now, what if I told you that, just keep them up. Now, what if I told you that the person that he offended against was his girlfriend, and they got married, and they've been married for the past 20 years? If you think he's going to do it again, keep your card up. Okay. Now, what if I told you that is the only person he has ever had sex with? Keep your card up if you think that he will do it again. Okay. So the cards are starting to go down. Now, what if I told you that he ends up on an island? This is Gilligan's Island. You can never get it off. It's just him and his wife and his children. So that's it. Who here believes that he will do it again? Okay, what if he's on Gilligan's Island alone? Okay, so, all right. So I just want to talk to you. A lot of you had your cards up. Would you agree? Can someone who had their card up, can I talk with someone? Someone who had it up, can I have a volunteer? Number 41. Did you end up putting your card down at some point?
No, ma'am.
Okay, not even towards the very end?
No, I didn't.
Okay,
Well, when he was alone.
okay, Billy's out. Okay, well, I'll still talk with you. You ended up hearing new facts, new details, new quote evidence, right?
Yes, ma'am.
And is that ultimately what changed your mind?
Well, but I didn't change my mind until he was alone.
He was alone. Okay, so let's talk with someone else. Anyone else? Well, at some point you put your card down, is that right?
Yes.
Before he was alone on an island? Okay. When you put your card down, would you agree it's because you heard something additional, you heard new evidence?
Yes.
Okay, so what I want to talk about with all of you is that at the very beginning, you heard sex offense, right? And it put a strong reaction, a strong feeling inside of you where you're like, you know what? The person's gonna do it again. And you didn't give much thought to it, right? Then you started hearing more facts, more details, things started to change. Would everyone agree? And when you started to hear that additional information, it changed your mind. That is how trial works. What we need to make sure is that all of us have these gut reactions. I'm asking you to think about it for just a moment and ask yourself, okay, can I listen to all the evidence, everything that is presented in front of me before I make up my mind in this case? If you can do that, and you can give the respondent a fair trial, then you can sit over here and be a juror, okay? So, as the judge said, or maybe she didn't, but this is a civil case, not a criminal case. So we're gonna shake things up a little bit, it's a little different. Now, in a criminal case, you are asked, is someone guilty of something? Or is there a no finding of guilt? We're not doing that here. what we are asking you to do is answer a question, yes or no. And you'll understand once I start going into the law and explaining it a little bit more. But I want you to think of a moment, think of some kind of criminal offense in your mind. Can everyone do that? Throw it out. That's not what we're here doing. It's not a criminal case, and I just want to stress that to you, okay? All right, so what is this case? This case is from chapter 841 of the Texas Health and Safety Code. And the question that you are here to help answer is, do you find beyond a reasonable doubt that the respondent is a sexually violent predator? That is the question. It's going to be yes or no. And I'm going to explain that law to you. So a sexually violent predator is two things. One, the person is a repeat sexually violent offender. That means they have more than one conviction, and I'll explain a little bit more. And two, the person has a behavioral abnormality that makes them likely to engage in predatory acts of sexual violence. So I want to ask a few questions. When I said sexually violent offense, can someone give me their understanding of the word violence? Anyone? Number 18. Okay, like physical violence, right? Hitting, punching, that kind of thing. So I want you to throw out that definition. That is how I would have answered the question. But in this setting, there are specific definitions that you have to go by, and we will provide those definitions. Violent in this, for this case, does not mean physical violence. It simply means a sexual offense. And there's a list of those sexual offenses. So for example, an attempt to sexually assault someone, not even touching them at that point, that can be considered a sexually violent offense. Indecency with a child, simply touching a child, how awful it is, that is considered a sexually violent offense. So you don't have to have that violence that you think of to meet that definition. Now, I also said repeat sexually violent offender. Can someone give me their understanding of the word repeat? 20.
I do it more than once.
More than once. Does it have to be over a certain period of time or?
No.
Okay. You actually got it right. So a lot of times when people hear the word repeat, they think someone did something, then they did it again, and again. Based on this law, it just simply means 2 or more. So what that means is someone can commit a sexual offense on the same day and do 2 sexual acts, which would get 2 convictions, and that would be considered a repeat sexually violent offense. Okay, so we have to look at the definitions. One more for you. You heard behavioral abnormality. Is there anyone here who can tell me what they think of abnormal? Behavioral abnormality. Anyone? 15. Not normal. Okay. That's how I would have answered it. Throw it out. There's a specific definition, and I will talk about that definition. But I want you just to understand when we're talking about these words, there are specific definitions that we have to use. Can everyone agree to do that for me? Okay. Now, one of the requirements that we have is we must prove both elements. So remember I said a sexually violent predator is 2 things. 1, repeat sexually violent offender, 2 or more offenses. And 2, they also have to have a behavioral abnormality. What I need to know is, will you require me to prove both of those elements? And I'll explain to you why this is so important. Many times people will tell me during this process, if I hear there are 2 or more convictions, I'm done. I am ruling with the state. I don't need to hear any more evidence. You don't even have to prove anything on that second part. That's not us meeting our burden. I need to make sure that you're going to require us to prove both elements. So I'm going to go row by row and ask, will you make me prove both elements? So look at my chart here. All right, so this first row, 1 through 7. Even if you hear that there's more than one conviction, will you make me prove the second element that he also has a behavioral abnormality before you make up your mind in this case? If it is no, raise your card. So I understand you're all going to make me prove both elements. Okay. Second row. Will you make me prove both elements? If you are going to say no, I will not, raise your card. Thank you. So this row right here, if you will not make me prove both elements, raise your card. Okay, so number 19. So just so that we're hearing each other correctly, if you hear there are 2 or more convictions, at that point you're saying, yep, I don't need to hear anything else. Okay, I'll come back with it.
I understand the question, what you're trying to say now.
Okay, and that's number 18.
I cannot, I mean, if you say you 2-3 times already.
Okay. Okay,
All right, everyone, just one moment, and I'm just gonna pause your time. When she's talking, she is not talking about the gentleman who's in this court today. These are all hypotheticals. And what she's doing is telling you what the law is and what they have to prove. So basically what she's asking, well, not basically, she's asking whether or not you're going to follow the law. All right, you may resume.
thank you, Judge. So before I go on, who here hates the idea of sexual offending? Raise your hand. Okay, everyone, right? Who here understands that when there's a sexual offense, it's creating a victim? Okay. All of us understand that. Who here has a very strong feelings, has very strong feelings when they hear that? Okay. In order for us to seat jurors, we have to have people that can say, this is hard, but I will listen to that first bit of evidence. Remember when we did that fact scenario? That strong feeling came up, right? He's gonna do it again. But then you started hearing more evidence, and that's what I'm asking you to do. Will you make us give you more evidence to prove that second element before you just make up your mind and say I'm done? That's what I'm getting at here. So number 18, if you hear there are 2 or more convictions, again, it doesn't have to be over and over again. It just simply has to be 2 or more convictions. Are you saying you will not make me prove my second element? You're already saying he's a sexually violent predator, you're done. I need a verbal response. If you can say it out loud for me.
Yes.
Okay, all right, thank you, number 18. Number 19, now that you've kind of, are you 19? Okay, now that we've kind of talked about it a little bit, are you still saying you're not gonna make me prove? Okay, and then, okay, anyone else on this row saying they're not gonna make me prove those elements? So then I'll come back to you. We're gonna be on this little row right here, the second row. If you will not make me prove both elements, raise your card. Okay, third row back. If you hear just that there's 2 or more, you're not gonna make me prove that second element. Anyone? Fourth row. Number 37. And if I can have you stand up, I can't see you back there. Thank you. Are you saying you're absolutely done? You're not gonna make me prove my case? Okay, thank you. 40. Same question.
Yes,
Okay, thank you. Anyone else the row after that? The very back row. 51. You're saying that you are not going to make me prove my case. And if you can be louder.
Yes.
Thank you. 52. You hear that there's 2 or more convictions, you're done, you're not going to make me prove my case. Okay, thank you. 55. You're not going to make me prove my case. Okay. All right, so I'm gonna go over here, this little row, the second row, third row, fourth row, fifth row. So just so that I understand, everyone on this side of the room, they're gonna make you prove both elements before you roll for the state or for the respondent. Okay, 53.
Is it different people or does it say
I can't, that's one of those things, I can't go into the details of this case. All I can say is that the law says if there are 2 or more convictions, you're not gonna make me prove that second element. If that helps. Now, with everyone who had raised their card, I wanna also throw this out there. You can use the fact that someone has 2 or more offenses to help answer that second question, but it can't be the only thing, okay? So you could say, oh, well, there's 2 or more convictions, maybe that's abnormal behavior, but I need to hear a little bit more. And it's not abnormal behavior, remember, there's this very specific definition. That's what I'm getting at. So if there's anyone who raised their card a moment ago and you want to change your mind and say, okay, as long as I can consider that for that second element, I'm okay. Okay. All right. Now, a lot of times these cases, or I'll start off this way. Who here agrees that when there's a sexual offense, there is a victim, right? Who here agrees that no matter who the victim is, it's a vulnerable victim? Okay. Now, I can't go into the facts and details of this case, but what I can say is that every case I try, if we're able to prove it, there's a victim of some sort, whether that be a child, an adult, a male, female, prostitute, best friend, whatever it may be. They're a vulnerable victim. So what I need to ask you is, if you hear in this particular case that there's any evidence of a diagnosis of pedophilic disorder, or there's any evidence of a child victim, who here is saying that alone will make me say, I'm not going to make the state prove their case. That detail alone, I'm determining my opinion, and I'm done. I am already saying the state won their case. Is there anyone here who feels that way? All right, I'll come back. So with everyone who said, kind of raised their card, yes, I want to speak with you. I actually want to speak to the whole room. Who here has a family member who's a child that is very dear to their life, very dear to your heart? Who here hates the idea of sexual offending against a child? Again, we need individuals who can say, this is hard to listen to. This is difficult. I have a strong feeling about that. But I'm still going to look at all of the evidence before I make up my mind. Now, if you hear there's a child victim, that can be a very strong piece of evidence for you, and you can consider it. It can be very strong. It can't be the only thing. Okay, so that's where I'm coming at. It cannot be the only thing you consider, and then just say the state won simply because there's a child victim. Does that make sense? Okay, so I'm going to go row by row again. If you hear that there's a diagnosis of pedophilic disorder or a child victim, that alone is enough, and you will not make me prove my case. You're not going to listen to any other evidence.
What is that disorder?
So pedophilic disorder is having a attraction to children, or they act upon it. Some people don't act upon it. It's just an attraction to children. Now, again, I'm not talking about the details of this case. I just have to talk about all of these things with every jury panel, right? Again, you can consider if that is truly what happened in this case, you can consider it for your ultimate opinion. Just can't be the only thing. You're going to make me give you all the evidence first before you make up your minds. So, row by row, if you hear there's either a child victim or a diagnosis of pedophilic disorder, you're shutting down. You're not going to listen to any other evidence. Row 1, row 2, 11. So you're saying if you hear there's a child victim, you're not going to listen to any other evidence that I put on. You've already made up your minds.
My wife was the victim, over 50 years ago, and she's still dealing with it.
So I'll come back, and I just want to ease everyone's mind here. I will ask about those kind of things in a moment. I'm not going to go into detail. I'll even answer my questions first to let you know what I'm looking for. So don't get too nervous here. So I understand where you're coming from, and we all know that when a victim is victimized, it can affect them for a very long time. But that's not the question we're asking. Okay, the question that we are asking is, if you hear there's a child victim, period, or this diagnosis, you're not gonna listen to any other evidence. It can be very strong for you, and it can affect you, but at the end of the day, I need to know that you are going to make me prove my case before you make up your mind. So if you hear that there's a child victim, are you telling me you're automatically saying the state won in this case, and you're not gonna listen to the evidence?
It'd be very hard.
Okay, so I'm gonna push you a little bit harder, and I had a judge one time, so this is where the joke comes from. He said, if I was going out to Vegas, and my wife said, behave yourself, and he goes, it'll be kind of hard. That's not the answer she's looking for. She wants a yes or no, right? So I hate to push you, knowing that it's hard for everyone.
Right.
It really is. The question is, will you still be able to sit here and say, this is difficult, I don't like it, but I'm gonna make the state prove their case. I'm gonna give him a fair trial, no matter what. Can you do that?
So,
No? Okay, and your number is 11?
11.
Thank you, sir. Anyone else on this row? All right, first row. And I think we already have 18 and 19. Is that correct? Number 16. Are you telling me that if you hear a child victim, you're not going to listen to any other evidence? That's the only evidence you need to hear. You're not going to follow the rules and the law that is provided. Yes? Okay. If you can speak louder just for the court reporter. Yeah. Thank you. Second row. Third row. 30, I'll come back to you. 36. Are you saying, if you can stand up for me, please, sorry. Are you saying that if you hear there's a child victim, you are not gonna make me prove my case, and you're not gonna follow, so we're gonna give you an instruction what the law is, you're not gonna answer that law based on that? Oh, that's really worded. You're telling me if you hear there's a child victim, you're done, you're not gonna follow the law as it's provided to you. Okay, if you can, it's really hard with the math.
Right, no.
Thank you. And then, sir, what was your number? 34. Just so that we're hearing each other right. If you hear there's a child victim or a diagnosis, that's the only piece of evidence you're gonna look at. You're not gonna look at any other evidence that we provide or that they provide. You've already made up your mind in this case.
Data petitioning a child, I've heard the kids already to me.
So it's not guilt or innocence, remember that. We would have to prove that he's already been found guilty before. And then
To me,
we
though.
can, I'm sorry,
That's how I would feel.
okay, but we also have to prove that he has this behavioral abnormality, and it's a very legal definition. That it's like a congenital or acquired condition that affects their emotional and volitional capacity, predisposes them to basically do this again. And that was just a quick jumbled version of what that definition is. Knowing that it doesn't mean abnormal behavior, like there's a specific definition. Are you saying you're already answering that question with that detail alone?
Yes.
All right, thank you. The next row back, 38, okay, 37. 38, if you can stand up for me. So you're telling me you're not gonna listen to any other evidence? If you hear that detail, you're already done, state one. Okay, thank you. 39. Same question. You don't need any other evidence. You're not going to listen to any other evidence. You're already done. Yes, thank you. Anyone else on that row? 40. Anyone else on that row? The next row back. 45. If you can see that for me, sorry. You're saying you're not going to listen to any other evidence that's presented. That detail alone is enough for you to say the state won. You're already saying you're not going to listen to any other evidence. And louder for me, please.
Yes.
Thank you. Back row. 51. Okay, we already have you. 52. We have you. 54. Same question. You're telling me if you hear there's a child victim or a mention of it, you're not going to listen to any other evidence. You're not going to make me prove my case. Thank you. Okay, so over here, this little row in the front. Second row, third row, 65, and 66, so 65 first. You're telling me that you're not gonna listen to any other evidence, that detail alone is enough?
Yes.
Thank you. 66,
Yes, sir.
you're not gonna make me prove my case, that detail alone is enough to prove it for you?
Correct.
Thank you. Next row, 71. You're not gonna make me prove my case if you hear that detail?
Correct.
Okay, thank you. 71 or 70, sorry. Same thing, you're not gonna make me prove my case?
Yeah.
Thank you. Last row. All right. Sorry, it's dry. So, yes, what's your number? 68. Yes.
Just, it's been on my mind.
Okay.
In your scenario, you
Yes.
use victim and vulnerable victim.
Right.
They're-
It's just words I'm saying. No legal definition to it. Yeah, is that,
Yes,
okay.
I was looking if there was a.
No legal definition, just letting you know that anyone can be a victim and they're all considered vulnerable. That's kind of where I was going with that. Okay. So you might have heard me mention, we have to prove this case beyond a reasonable doubt. Okay, that's a criminal burden, so some people might be confused by that. Even though this is a civil case, we're dealing with important issues, something that it deserves a higher burden. And so I must prove my case beyond a reasonable doubt. Is there anyone here that would like to volunteer and tell me what their definition is, or what you think the definition is? For beyond a reasonable doubt? What's your number? 20, what was that?
To have the evidence, like factual evidence presented and have no doubt, like there is no reasonable, there is no nothing, everything's black and white, basically.
Okay, black and white, no doubt.
Pictures or whatever.
Okay, 42,
All questions are answered.
all questions are answered, okay. So, I'm gonna give you how I look at it. So first off, there is no definition. You get to determine for yourself what beyond a reasonable doubt means. So some people, it might be a little higher than other people. It's your definition. What I can tell you is it's not beyond all doubt. So it doesn't mean 100%. You can still have questions and be like, oh, I wish I knew this or that, or have a question on some other issue. But ultimately, everything was proven to you enough to know that this person has this condition, right? So that's kind of where, that's kind of how I look at it. I'm gonna give you an example. So if I came in here today with an umbrella and I'm shaking it off, my pants are wet, my hair is all crazy like it is today anyways, and I said, man, it's coming down out there. What's going on? It's raining, right? Is it possible that I jumped into the fountain outside, took a little swim and came in here? It's possible. Did I jump in a fountain?
No.
Probably not, right? So it's unreasonable for me for that to even occur to you. So beyond a reasonable doubt, I'm wet, there's an umbrella, everything is pointing to it's raining. Okay, so that's kind of how I look at it. There could be some weird explanation outside of it, but everything that was presented to you, it's raining. Is that definition okay with you, number, is it 20? Okay. Is there anyone here after hearing that still says it's 100% proof? The state must prove 100%, no doubt in my mind at all. It's okay for you. Okay. All right, this burden is the state's burden, meaning we have the burden in this case. I must prove my case to you. You might want to hear from the respondent, but they do not have to put on any evidence at all. I must prove my case. So with that said, if I came in here and I brought 10 experts, 10 witnesses, they're fantastic, or they're horrible. You don't like them, you don't believe anything they said, but they brought no one. But you don't believe anything that any of my witnesses said. Who wins in this case, me or the respondent? The respondent. I can bring everything, but you don't believe it, I didn't prove my case, the respondent wins. Who here wants to hear from the respondent? Okay, but he doesn't have to, okay? The state must prove our case. Can everyone here hold me to that burden? They're gonna make me prove my case, and they're not gonna make me disprove anything. Is there anyone here who says no? If I don't hear from the respondent, the state automatically wins. It's okay if you feel that way. Am I doing okay on time?
You have 29 minutes.
All right. So going along with that, this is not Law and Order. Who's ever seen that show? It's like 500 point, like part 592. No, we do not practice law like that. My goal here today, and Olivia's goal, is to bring all the evidence necessary to prove our case, and then we're going to sit down. And if that means we use a few individuals or a few pieces of paper evidence or whatever it is, but we prove our case beyond a reasonable doubt, that's enough. Is everyone okay with that? Is there anyone here who wants to hear from everybody? You want this to be that 10-week-long trial? Okay. We also have to prove this case with expert testimony. We talked about that second element. Does someone have this congenital or acquired condition that makes this person likely to commit these sexually violent offenses in the future? We have to prove that with an expert. Who here would like to volunteer what kind of expert they think that we should bring in this case? So the room is saying psychologist, psychiatrist.
Or the person who was treating whoever the victim is.
Okay, and that was number 20. Right, so someone who's treating someone who is a psychologist or psychiatrist, right? And the state intends to do that, and we intend to bring someone by the name of Dr. Jason Dunham here out of Texas. Is there anyone here who's familiar with that name? And I'll see if it's a friendly, exchange. Okay. I'm gonna use a big term here. I learned in law school. Who here thinks that psychology and psychiatry is a bunch of hooey? Junk science. All right, we got one. What's your number? 9. Okay. I appreciate that. Now I can tell you that my undergrad is psychology, but we're still okay. Is there anyone else who agrees with 9? Number 62, number 22. Okay, number 9. If you do hear from a psychologist in this case, are you going to automatically disregard their testimony? If I can have a verbal, sorry.
No.
No. Okay, so you'll still listen to them.
Sure.
All right.
Hear them out.
All right, you'll hear them out. You just have an issue with that.
No, I just don't think that anything they'd say it's like 100% concrete.
Okay.
Can be a factor, but that were like the only evidence.
Okay, I appreciate it. Thank you for your honesty. So I saw another number 22. Do you agree with number 9?
What he said, like, I don't put 100% trust in it.
Okay, but you'll still listen to
But I'll
it.
still listen to it.
Okay, thank you. 62, is that the same?
Yeah, I would listen to it still. I wouldn't just say no.
Okay, but you would have some issues with it.
Yeah, and it's just personal, just so that, I had daughters that went through that and just didn't feel that it was for them, that it really did anything for them.
Okay, I appreciate it. Thank you. Anyone else? All right, thank you guys for your honesty. I appreciate that. Are you guys okay with experts utilizing records in a case? Like reviewing records, that kind of thing? Very quickly, if you hear evidence in this case and someone says, please, the judge says disregard that last evidence that you heard, you're not allowed to consider it. Are you able to follow the law as the judge gives it to you, or are you going to say, I'm sorry, there's a bell rung, I heard something, it's important to me, I'm not going to follow the law, I'm not going to follow that instruction from the judge? Is there anyone here who's like that? 71 and 67. So 67, if the judge tells you, hey, I know you just heard some evidence, but you're not supposed to consider it for whatever reason, you're saying you're still going to consider that?
I would have to agree with judge, but inside of myself, I would not agree with that.
Okay. So if you were back in the jury room and they said, don't consider that evidence, are you going to consider that evidence?
Personally, I will, but I'm not gonna argue with judge.
Okay, thank you. Thank you. It's very So back there, you're gonna consider it each time you tell the judge.
My decision, I would say at the end, it's gonna make my mind.
Thank you, thank you. And then right behind, Cheryl, what was your number? You raised it, right?
Yes.
Okay, are you saying the same thing? Okay, and pretty much like if you do hear that evidence, you're,
I think, yeah, if I heard it, then, you know, I'm in the process. It's gonna-
Okay, stand up, please, and speak up.
If I heard it, you know, it's gonna affect my decision.
okay, thank you. 18,
Why do you think we hear, like, if it's the truth, but somebody changes it around, and the judge says, don't listen to that?
okay. So the reason why this comes up, and honestly, it doesn't happen often. I've been a part of many trials, and maybe only once has something come in where the judge like completely disregard that. There is a lot that goes on behind the scenes where the judge says this is reliable information or it's not, or it's hearsay, meaning it comes from someone else that you can't question in court. There's reasons why some things shouldn't be brought in to the courtroom, and that's dealt with beforehand. So what I'm asking is, will you trust the judge in her saying disregard that it's either not reliable or shouldn't have come in, that's basically what I'm getting at.
It would be a little bit hard, but I would try and, you know, follow her rule.
Okay, thank you, sir. All right, so I'm gonna move on to an area that can be a little difficult, but I promise you, I'm gonna answer my questions first to kind of soften that flow. I know this is difficult in front of a whole bunch of people. But if this was a DWI case, so drunk driver case, if you were the respondent, would you want to know, okay, is there someone in there who's on MAD, Mothers Against Drunk Driving? Or has someone, I would want to know if there's someone out here who lost a family member to a drunk driver, that kind of thing. That's the only reason we're asking these questions. It's not to pry into your life. It's simply to find out how strong is this bias, how strong is this experience, okay? So the questions I'm going to ask is, without giving any specific detail, have you, a close friend or family member, ever been a victim of sexual abuse? However, whatever form. You can put them down. I'll go row by row. My next question, so I'm going to answer that. My answer would be yes. My next question would say, was it reported? Yes. Was it handled by the judicial system? Yes. Was the outcome fair? No, the person skipped bail. Okay. Knowing that, would you still be able to sit on this case, listen to the evidence, and provide a fair verdict? For me, I would say, I know that this isn't the respondent, it's a different person, different details, different facts. And I have gotten to a point where I'm okay to listen to that kind of evidence. Will it be difficult? Yes, but I can be fair. That would be my answer. So that is the amount of detail I'm asking for. I do not need to know if you yourself was a victim. I don't need to know details. I don't need to know any of that. Okay, so if I still ask you a question that's too difficult to answer, if you can just give me a timeout, symbol or something, I can ask the court if we can come up. Is that okay?
Yes.
With the judge and ask the question outside of all of your peers. So I'm going to come over here first. This first row, have you, a friend, or close family member ever been a victim of sexual abuse? So number 2, was the offense reported? Okay, would you have wanted it to be reported? Okay, and if you guys can speak up, it's really hard for the court reporter to hear. And is there anything about that case that would prevent you from listening to the evidence in this case? Thank you. Number 3, was the offense reported?
Yes.
And was there a conviction?
Yes.
Were you okay with that conviction?
Yeah.
Okay. Is there anything about that experience that would prevent you from listening to the evidence in this case?
I think so.
Okay. So, well, do you understand it's a different person and different facts, different scenarios? Is that right? Okay. My question then, I have to push a little bit farther. Will you give the respondent a fair trial? Thank you. Anything else here? Number Yes.
What's the difference between abuse and assault?
So for this purpose, it doesn't matter. So any kind of sexual anything that was unwanted, that's where I'm going at. Right now, it's not a legal term. I don't need any of that. It's just having been affected by something. That's what I'm looking for. So number 5, was the offense reported? Would you have wanted it to be reported? Is there anything about that experience that would prevent you from listening to the evidence in this case? No. Thank you. This row. Number 10, was the offense reported?
I don't know.
Okay. Would you want it?
You said a friend, right?
Yes,
Okay,
yes.
yes.
Would you have wanted it to be reported?
Yes.
Okay. Is there anything about that experience that would prevent you from listening to the evidence in this case?
No.
Number 11, was the offense reported?
Yes,
Would you, was there a conviction?
yes,
Were you okay with that result?
Yep.
Is there anything about that experience that would prevent you from listening to the evidence in this case? Thank you. Okay, this row. 16, was the offense reported? And was there a conviction? And was there anything about that experience that would prevent you from listening to the evidence in this case? Yeah. Okay, and we already have you, so I'm just gonna leave it at that. Number 17, was the offense reported?
Yes.
And was there a conviction?
Yes.
Were you okay with that conviction? All right, so if you don't mind me asking, did you believe that person accused was innocent?
Yeah.
All right, would you wanted more or less time? Is that?
Yeah.
Okay, do you mind me asking you, just not about the offense itself?
No, like, it was a friend that like just got off of probation.
Okay, so you would have wanted something more? Right. I gotcha. Is there anything about that experience that would prevent you from listening to the evidence in this case? Okay, if I can push it for a yes or no. I'll ask you this, will you give the respondent a fair trial?
Yes.
Thank you. Anyone else? I think we have 18, we have you, sir. Anyone else here? Okay, I think we have you as well. This next row, 23, was the offense reported? Yes. And was there a conviction? Would you have wanted to see a conviction?
Yes.
Is there anything about that experience that would prevent you from listening to the evidence in this case? Am I talking too fast?
A little quick.
Okay. Thanks. We start mumbling the same words, so I just want to make sure. 24, was the offense reported?
No.
Would you have wanted it to be reported?
Yes.
And is there anything about that experience that would prevent you from listening to the evidence in this case?
Yeah.
Thank you. 27, was the offense reported?
One was, one wasn't.
Okay. I'll ask you this way. Was anyone convicted and you were not okay with that conviction?
No.
Did anyone not get convicted and you were okay with that?
Yes.
Okay. Is there anything about either of those experiences that would prevent you from listening to the evidence in this case?
No.
Thank you. All right, the next row. 30, was the offense reported? And was there a conviction? Would you have wanted to see a conviction? Is there anything about that experience that would prevent you from listening to the evidence in this case? Thank you. Anyone else on that row? 34, was the offense reported?
No.
Oh, I think we have you, sir, from a prior response. Anyone else? 35. Okay. Was the offense reported number 35?
I have 3 separate.
Okay.
Hold on, stand up and a little louder, please. Okay, 3 separate events.
Okay, so, let's just do them quickly, one by one, because that's a lot there. I'll ask you this, were there convictions on any of them?
Yes.
And were you okay with those convictions?
Yes.
And were there, was anyone found not guilty or there was no conviction on?
2 were not reported.
Okay, 2 were not reported. Would you have wanted those to be reported?
No.
Okay.
Did you say no or yes? No.
And did you believe that the person accused did not commit the offenses?
Yeah.
Okay. Is there anything about that experience that would prevent you from listening to the evidence in this case? No. Okay, thank you. 36. Was the offense Okay, we have you. Next row. Okay, just you. 37. We have you. 37, 39. We have you. 41. Okay, if you could speak with me, 41. Was the offense reported?
Most of them were not, but there's one that happened 9 days ago that I'm hoping to.
Okay. Most of them were not. Would you have wanted them to be reported?
Yes.
Okay. Is there anything about those experiences that would prevent you from listening to the evidence in this case? Thank you. Next row. Back. Okay. 49. Was the offense reported?
No.
Would you have wanted it to be reported?
Yes.
Is there anything about that experience that would prevent you from listening to the evidence in this case?
No.
Thank you. Number 50. Was the offense reported?
Yes.
And was there a conviction?
I believe so, yeah.
Were you okay with that result?
I honestly, it's kind of a distant relative, so I actually don't know about the case.
So nothing there would affect your ability in this case? Okay, thank you. Last row. 52. We have you. 53. 53. Was the offense reported?
Yes.
And was there a conviction? Would you wanted to see a conviction? Did you believe those allegations?
Yes.
Okay. Is there anything about that experience that would prevent you from listening to the evidence in this case?
No.
Thank you. 56. Was the offense reported?
There's several.
Okay. Was there any of them? Were there convictions on any of them? Were you okay with that?
Yes.
Were there any unreported?
No.
Okay. The ones that were reported and there was not a conviction, were you okay with that result? Sure. So you said all of them were reported?
Yes.
But some of them did not reach a conviction?
Correct.
All right. Were you okay with that result or would you wanted to see a conviction?
No, I wanted to see it.
Okay. And is there anything about that experience that would prevent you from listening to the evidence in this case?
No.
Thank you. All right, this front row. 60. Was the offense reported?
Yes.
And was there a conviction?
No.
Would you have wanted to see a conviction?
Yes.
And is there anything about that experience that would prevent you from listening to the evidence in this case?
No, there's not.
Thank you. 59.
Yes, ma'am.
Was the offense reported?
No.
Were you okay with that?
Yes.
Okay. Did you believe the allegation that was made?
Yes.
Okay. Is there anything about that experience that would prevent you from listening to the evidence in this case?
No.
Thank you. Anyone else on that? 58. Was the offense reported?
No.
Would you have wanted it to be?
Yes.
Is there anything about that experience that would prevent you from listening to the evidence in this case?
No.
All right, next row. All right, 64. Was the offense reported?
No.
And were you okay with that?
No.
Is there anything about that experience that would prevent you from listening to the evidence in this case? 62. Okay, 62. Was the offense reported? And was there a conviction?
Yes.
Were you okay with that conviction?
No.
All right, would you wanted to see more or less time?
Less.
Thank you. Is there anything about that experience that would prevent you from listening to the evidence in this
No.
case? Thank you. Next row. 68. Was the offense reported?
No.
And would you wanted to see it reported?
Yes.
And is there anything about that experience that would prevent you from listening to the evidence in this case? Thank you. Next. 66. We already have you. Thank you. 67. Did you have your card? Or 65, I'm sorry. We have 65. Thank you. Next row. 72. Was the offense reported?
Yes.
And was there a conviction?
Yes.
Were you okay with that conviction?
Yes.
Is there anything about that experience that would prevent you from listening to the evidence in this case?
No.
Okay, last row. 75. Was the offense reported?
No.
Would you wanted it to be reported?
Yes.
Is there anything about that experience that would prevent you from listening to the evidence in this case? Thank you. Okay, I'm coming to an end here. a few of you talked to me about not believing allegations, so you don't have to speak up again. But is there anyone here who has a friend, yourself or a close family member who has ever been accused of a sexual offense and you did not believe that allegation? If that's you, if you can just raise your card. All right, so 39, 53, 54, 35, 56, 69, 15. Did I get everyone? Okay. Of that group of people, is there anyone here who has a negative view of the state, the petitioner, because of your experience with that situation? Okay. All right. So I'm wrapping up here. I just wanted to ask you about your feelings about sex offenders. Do you believe that they get a fair shake in society? Or do you think that the state is too harsh? If you think that what happens is too harsh, you can let me know. And it's okay if you feel this way. We all have experiences. 41, it's too harsh. Thank you. Anyone else? Okay, and then 41, just to make sure, you're not just talking about like some people are considered a sex offender because of public urination or something like that. Are you just talking about sex offenders in totality or something specific?
I believe that even for sex offenders, like violent sex offenders, that there's a belief that they cannot be rehabilitated.
Okay.
And I don't agree with that.
Okay, thank you. Is there anyone who agrees with number
41.
41? Okay. Number 3. So you're okay with what happens as far as how the state treats them, but you think that they can change? Is that okay? Is there anything you wanted to add? And if you can say yes or no, sorry.
Yes to the first question, no to the second one.
Thank you. Did you have yours up? Okay. My question this way. Help me out here. Why did you raise your card?
We agree with 41.
Okay, thank you. And you agreed as well, number 12?
Yes.
Now, the agreement, is it that the state is too harsh on them, or that you still believe they can change? Number 9.
That they can change.
Okay, thank you.
Mine is that, and also it kind of what you said about urination, public makes it a sexual offense, and sometimes I've heard of instances where it doesn't seem like it was something that was wrong, but it was considered a sexual offense. My definition of it not really match that.
That's fair. Follows them for the rest of their life. So if I was to take out like the public urination, even the teenagers who were like a few years apart, that kind of thing, if we were to remove that from it, do you believe that all other sex offenders are treated fairly in society? Number 3. Thank you. Number 9.
By and large, yeah.
Okay, thank you. And then number 12.
Yes.
Okay, thank you. Anyone else over here add to that conversation? Okay. Okay, I'll come back. 24.
I think there are a lot of groups that are treated unfairly, and this is one of them. I mean, I'm not gonna say that I agree, but there are a lot of groups that are marginalized in this.
Okay. And then what was your number, 62?
Yeah, I agree that, they can change. And the way the system treats them.
Hold on, I'm sorry, stand up and speak louder, please.
I agree that they can change when they get out from jail or something, but sometimes the system does not treat them all fairly. I mean, it just depends on what the case is for them.
Okay. What would you like to see, and I'm gonna be very specific, if there's a sex offender in prison? How can you see change with that person in that setting? Anyone want to help?
One-on-one services for that.
You could raise your card, sorry, 20.
One-on-one services for that offender, more training, more understanding the disability or what is going on with that person.
And if I can change my question a little bit, specifically for that person, how can you see that they change? Not necessarily how we can get them to change, but.
Well, they can't change in prison without help.
Okay. Does their response to that help matter? So would you agree that sometimes you can be offered help, but you might not want to take that help? Or you don't apply yourself, that kind of thing? Would you want to see, what kind of application from that person would you like to see?
Them to receive the help or want the help.
Want the
Want
help?
to be helped.
Okay. Number 41.
My brother is a psychologist who's worked with sex offenders for decades.
Right.
In different, and based on his experience, you can tell whether or not they're responding to therapy and actually doing work. That there's,
How can you tell from their response? Like, what kind of things are you looking for?
I mean, he talks to me mostly about positive versus negative experience. I mean, he can't give me details, like you can't give me details, but he talks about successes versus most of them don't respond, don't put in effort. But there are those that do, that seem to really want to change, whether that works or not. That's kind of we're hoping that the investment in them is something that will be paid off when they're
We hope that some people grasp onto that, right? Okay, I agree. Number 3.
They find Christ.
Okay.
A lot of people in jail turn to God and the Bible, and they have a changed heart and are truly believe that.
Okay. Finding, and I'm just gonna broaden that.
Excuse me, just 1 second.
Yes.
Excuse me, sir. This is the way this works. When there's questioning going on, you just can't leave. If when anyone needs a break, you raise your hand, then what ends up happening is we all leave together. And when I say we all leave together, that means all the jurors will have to leave together. But while questioning is going on, that's not allowed because everyone has to be in the same group. But if you need a break, then we can give you a break. Do you know how much longer you have?
This is the last really question, just to flesh it out, and after that, I'm done.
All right, thank you.
Are you okay for like less than 5 minutes? Okay, can you wait 5 minutes, or do you need to? leave
2
now?
minutes and 40 seconds.
Okay, 2 minutes and 40 seconds. So my question is, what would you like to see from that person to see change? And then you talked about religion. If they find religion, them saying that alone, is that enough, or do you need to see more? 67.
I believe it has to be a medical treatment, and I believe jail is not really saving situations like that. It making people worse. I believe the medical institutions or mental health institution are more suitable to those cases.
Anyone else? Anyone here say finding religion is enough? So they can find religion, that's a good thing, but you need to see a little bit more. Is that what you're saying? Yes. Okay. Okay. So I'm gonna go ahead and step down, but I wanted to leave you with this. Remember, you can have a bias, you can have a strong opinion, but when you're asked about your biases, just really think deep and hard, can I be fair? Can I give him a fair trial? I understand you have things that you're holding with you, and that's okay. That's fine. But just remember, if you're asked, do you have a bias, you can just speak out and tell them what you mean by that. Like, I have something that I'm considering, but overall, I'm gonna give them a fair trial. But of course, I hear my experiences. Does that make sense?
Yeah.
Okay. All right. Thank you very much.
All right, thank you. Ladies and gentlemen, what I'm gonna do is I'm gonna give you a break. If everyone can be back here by 11:05, and here's the thing, we can't start unless everyone is here. So look to your left and look to your right, and remember the person there. Sort of like paper chase. All right. I'm sorry, what did you say?
Leave their stuff here.
Yes, yes. Everyone, you can leave your stuff here if you like. The deputies will be here in the room.
Your Honor.
Yes.
There's someone asking me a question.
Yes. I'm sorry, go where? Oh, just remain in the courtroom, okay? All right, and both counsels could remain in the courtroom. Everyone, I have allergy ears, so it's hard for me to hear.
Everyone has
Make sure you guys wear your juror stickers and let me know you are a juror. Do I have to have it to come back in? Do you remember when? No. Delete. Here. He has a question.
Oh,
okay. You have a question too?
Okay, all right, we're gonna go on the record. And if you could approach, sir. You're juror number 18.
Judge,
Council can approach.
the questions that she was asking about
Just a second. All right, I'm gonna turn it over to the respondents. So you may begin.
Hello, everyone. Introduced to you earlier, my name is Charles Martin, representing Mr. JOAQUIN RIVERA. And everybody told you kind of what this is about. The way I look at it is this is like a party. We're hosts of the party, and as a host of the party, it's our job to kind of walk around and talk to everybody. And what I'd like to do is I'd like to get everybody in the jury box to just take a quick, stand up, just real fast. In the jury box, just here in the jury box. Just here in the jury box. Because what jury selection is trying to pick a jury. All we need is 12. In this case, we'll have a couple of alternates, so 14. That would be this box right here. Now look around, look how many people are in our party, right? It's a lot of people. You gotta see. Now, when we're trying to pick a jury, what we're doing is we're looking for, we don't get to come by and say, we select juror number 13 in the draft. We don't get to do it that way. The way we do it is we strike people that we think are not going to be fair and impartial. And it takes a long time. It takes a lot of communication. I once had an attorney tell me that it took me 12 years to learn that I needed to divorce my husband, but I only get a couple of, a few minutes with the jury. How am I going to know what their true being is? And it's difficult. If you don't communicate back with us, if we're not communicating with you, it's very difficult to find out who is going to be the right fit. And we invite all of you to this party because we know that there's areas that are going to be difficult, right? Not everybody is going to be the right fit for the right trial. Came in here into a criminal district court, and the trial is titled "In Re the Commitment of JOAQUIN RIVERA," right? A civil case with a burden of beyond reasonable doubt. Now, it should be confusing because I talk to attorneys all the time. I saw an attorney yesterday. He had no idea what this was. He was coming up to court for a criminal case. He's like, why does it have a beyond reasonable doubt if it's civil? It can be confusing. But what we want to do is we want to try to weed out those that it's not going to be the right fit. And all we ask for you is to be honest with us. We're going to ask questions. You were very honest and open earlier, and I hope that you'll continue to be open and honest. And the importance of it is, Ms. Janice talked about it earlier, is bias. And she said, if it's bias, I want you to think about it as, can you be impartial? Can you sit, listen to the facts of this case? Use only the facts of this case. The instruction given to you from this court to answer that question, that yes or no question. Now, I'm going to back up a little bit and apologize because I travel a lot. And when I go into different areas of different allergies, my voice will get really scratchy. So I'll try to not drink too much water. I do want to come back to this beyond reasonable doubt real fast because what we talked about earlier is that it's not all doubt, but it's up to each and every one of you. We don't have a definition for reasonable doubt in the state of Texas. We used to, we don't anymore. And this statute, this law, is going to have a lot of things like that are not defined. Terms like likely, terms like predisposed, they're not going to be defined. And when they're not defined, they're up to you to define them in a normal way, right? So it's an important kind of thing. But the importance of being in a court in an adversarial environment is that you do get down to kind of the middle of the road, right? It's not what one person says versus another person saying. It's about what facts are presented and how do those facts get whittled down into what becomes the information that we're gonna take back to the jury room to use to answer the question. So Ms. Janice gave an example of, she's walking into the courtroom, she's soaking wet, she has an umbrella, she says, man, it's really coming down out there. Everybody's like, it must be raining. Well, I sit there and I think, well, hold on a second. Is there a sprinkler system? Has that sprinkler system been serviced? Is there some kind of problem with the sprinkler system? Is there a fire down the street and there's overspray from the fire truck? Or are they like power washing the exterior of the building? All of those are plausible other options. So when you're looking at reasonable doubt, you don't need a lot. All you need is one doubt. In that doubt, all you have to do is attach a reason. That's reasonable doubt. Now, it's different in everybody's eyes, but you've got to hear the other side of the story. You can't just say, there's an umbrella, person's wet, and they say it's coming down, and it must be raining. Did we look at the news? Did we dress for rain that day? What are the other situations going on? And that's why it's important to have this kind of set. You don't make a determination until everything is put in front of you. Now you're going to be asked one question, and that's, do you find beyond reasonable doubt whether or not respondent, Mr. JOAQUIN Rivera, is a sexually violent predator? And you're going to have two options, yes or no. That's it. You're going to be given some definitions, and those definitions are going to be pretty weighty, right? Behavioral abnormality, congenital or acquired condition that by affecting a person's emotional or volitional capacity predisposes the person to commit a sexually violent offense to the extent that the person becomes a menace to the health and safety of another person. You're going to hear another definition that is sexually violent predator has two parts. Whether or not they're a repeat sexually violent offender, which is defined as being convicted for more than one sexually violent offense and serving time for at least one. And then the second part of that is suffers from a behavioral abnormality that makes the person likely to engage in a predatory act of sexual violence. So does that scare anyone? Those definitions scare anyone?
They evoke a feeling of fear because the nature of what that means within the person and classification. No, yeah, I'm not scared. Yeah, I think that.
I didn't quite hear you.
It would evoke a feeling of anxiety, yes, just by hearing it.
Okay, and is that hearing, is the emotion that you hear regarding the sexual offending, or is it regarding the definition of what a condition is and things like that? And I do want to break some things down a little bit. Congenital or acquired condition, so just a condition, right? That by affecting a person's emotional or volitional capacity. Does anybody have any kind of thought on what that means to affect a person's emotional or volitional capacity? Number 20.
I think that's like a mental, like a cognitive type thing, of like a learning disability, or like a disability where things don't come together when it's time to process.
So it's not defined in the statute. The way that they look at it, I think you probably might hear something like it affects the person's ability to control behaviors or their emotional feelings regarding other people, right? So, you know, there's going to be some vagueness there. Anybody else have any kind of ideas? Number 13?
Hormonal changes.
I'm sorry?
Hormones changes.
Okay. That's a good point, because how our bodies change and how our minds change over time will affect our abilities to some extent. And that can be a positive or negative contributing factor for behaviors. Is that accurate? Predisposes the person to commit a sexually violent offense. What does that mean to be predisposed to do so?
Inclined to do it.
Inclined, what number are you?
Oh, I'm sorry, I'm 27.
27, inclined? Okay, so that means the condition would be causing you to be inclined to do something. By this definition? Is that accurate? Or is it? And that would be making you inclined to commit a sexually violent offense. So here we now have a condition that by affecting emotional or volitional capacity now predisposes a person to commit a sexually violent offense. So there's a lot of different steps here that we have to go through. And then the final one is to the extent the person becomes a menace to the health and safety of another person. What does that mean to you? Does anybody have an idea or a thought about what it means to have a condition that affects you to the extent that you become a menace?
On the community, you know.
I'm sorry?
You're on the community, you know, if you're a menace, you're pretty much gonna.
Okay, number 63.
A danger. I'm gonna just-
A danger.
I think danger.
Okay,
I would say danger.
Okay.
Danger does.
was there anyone else? Now, there's a lot of dangers in the world. And we don't always have to have a trial, right? Earlier you heard that the state has the burden of proof. They have the burden of presenting evidence. And they said that they have to prove this behavioral abnormality through expert testimony, okay? You're gonna hear from an expert, but that expert will not have kind of an answer for what it means to be a menace to the health and safety of another person. Because that's another thing that is gonna come to me. How, you know, where is this person in his life? Where is this person in his treatment? Where is this person in his development? And is he a danger moving forward to the extent that he becomes that menace? Now, when we talk a little bit about bias, what we don't talk about, or we didn't talk about earlier, is implicit bias. And I want to talk about implicit bias a little bit, because implicit bias is very, very important in our judicial system. Because what we want to do is we want to put 12 jurors in here. They're going to be able to come in. All of us have lives outside of those doors. All of us have past experiences, beliefs, thoughts. All of us have varying experiences that make us who we are. Okay? When we come into those doors, you say here in jury selection, you're here to be just honest and open. You come across that bar and you get into these seats, and you have another instruction. And that is that you have to suspend those biases in order to listen to the facts here and answer the question based only on that fact, on those facts, so that the decision is an impartial and fair answer. So what do I mean by implicit bias? Does anybody know what that means? It's kind of a hot topic right now. I mean, the legislature was talking about implicit bias tests given in elementary schools. Does anybody, number 31?
Subconscious bias that you don't recognize.
Subconscious bias that you don't recognize, right? So when we ask these questions about can you suspend that bias, do you have an experience? And does that affect your ability to sit on this trial? We have to be able to address whether or not there's gonna be a potential thing that comes up that's gonna trigger that unconscious bias, right? That's why we bring 75 people. And I've been in a trial before where something has come up and a note comes to the judge and the person says, this is too close to home. We can't screen for everything. And so what we want to do is we want to try to give you the opportunity to talk it out in this environment, the safe environment, to make sure that this is where you are going to be best served by, you're going to serve the community best. Does that make sense? Now, you guys sat through a lot earlier. Do you have any questions about what you heard? No. And I see some yawns. I always get to go second. That's not fair. No, I just. But I do want to ask some of the same questions, right? So if you hear that currently Mr. Rivera is in prison, does that affect how you think about this case? I see some nods. So does it affect anybody? Does anybody have concerns? Number 12?
Would that mean that he's already redeemed for this offense? Or you can't say, but so that would lead you to think he's already done it and he's already convicted. And so it would lead me to
So, and we're going to try to throw out guilt and innocence in this entire trial, because we're not here in a criminal setting. We're not here trying to, you know, there's no action that was committed by Mr. Rivera that makes him subject to a criminal proceeding, right? He's not here to be judged, weighed. He's not, you know, this is not about that. This is about a loose definition, a psychological definition, or a sociological definition about an emotional thing that has to be addressed when you hear evidence from the witness state. Okay? Everything you hear in this is not evidence. But when you get selected, you come in here, you're going to hear evidence from that box right there, the hot box, as I call it. That's where the truth comes. That's where the information comes that you will use as evidence, okay? So I work for an organization, and all we do is we represent inmates who are indigent. That's it. That's all we do. Somebody is sued in prison and they have no money, we step in. And that can be civil, like this, it can be criminal. Does anybody have a problem with an organization set up to defend those in need? If you hear that, oh, number 18.
You're saying that people that need help, or you're saying, like you said, that you represent the inmate?
Okay, so I'm going to answer it this way, but I think we have a lot of stuff. And you know what our organization does is we represent people for whatever they need, as long as they're incarcerated and indigent. It has nothing to do with anything else other than that. But some people do have a bias against public defenders. Some people have a bias against court-appointed attorneys. So I want to make sure that that's not going to come out during this trial. I believe that earlier you were asked whether or not, if you hear evidence that the person is convicted of a sex offense, more than one, serve time for one, there was a question about, will that be enough for you to just turn off? Will that be enough for you to answer the question? We went through a lot. I'm not gonna ask it right now. I'm only gonna ask like 4 or 5 questions. I'm gonna ask you guys to ask me questions. But I do it at the end because I wanna see if any answers change. Do you have a question? I thought I saw it. So at this point, does anybody have any questions about why we're here? Number 5.
I apologize, I don't really watch it. Can you explain the difference between criminal and civil?
Yes. So if you're charged with a criminal offense, what happens is, let's say, you're indicted, you're charged and you're indicted, and then you come in for, let's say you plead not guilty, you go to trial, then the presumption there is that you're innocent until proven guilty, that the state is alleging that you committed some offense. The state's required to prove every single element of that offense. And then if they prove that, and the jury says they proved it, then the person would go to sentencing. And that sentencing could be anything from probation that we had. Actually, if it goes to a jury, you're gonna get time. But there's gonna be a punishment assessed to it, right? And civil is different. Civil has a lot of different things. Juvenile cases are considered civil, even though there's a criminal element to it. Let's see. Products liability, accidents. I know I have a couple people that are insurance adjusters. Who in here works in the insurance? 67 and 45. So number 45. When you're you have somebody that's going to come to you and say, we want to get some kind of insurance policy, right? And you're an agent that would talk them through what they can get and how much it will cost. Are there things called an actuarial assessment that you go through to see how much they're going to be charged?
I can't hear you, ma'am.
Okay. Are you familiar with the actuarial? Okay. So if I'm trying to get automobile insurance, and I come in and I say, I've had 8 speeding tickets, 2 wrecks, and I've got a 16-year-old. That's all going to go into that actuarial? All right, I gotta find. Okay, so you have to take all of that information, take it into context, and then you make a decision whether or not it's appropriate for your business plan to move forward with that individual.
Repeat that, ma'am.
And that's kind of like what we're doing here, right? I'm kind of like trying to figure out what's going on with things to see where it's going to be. And it's not going to change throughout this trial. You're going to hear a lot of things about that. Earlier, you were asked if you can follow an instruction by the court. And I believe it was if one of us has something come out and the other attorney objects and says something, and that objection is sustained, and then we ask for an instruction to the jury to disregard. And there were several people that said that they'll hear it and they'll say they disregard it, but it's going to weigh in. If you hear that there's evidence of child victims, will that be so weighty on you that you're not going to be able to listen to the facts, follow the instructions? And does anybody have any responses or comments to that? Number 40?
Unfortunately, as much as I don't want to have a bias, I have small children, and I can't think past.
Right, everyone who's not on, remember the instructions, everybody who's not in the jury box and on this front row, I need you all to stand up so that the court reporters can hear.
Sorry. Having small children, I just can't put it out of my mind and past that thought. It's just, I know that's bias, but I just can't unfortunately get past that.
Number 13?
I think I'm the same page, page number. But I'm not a psychiatrist, I'm not a psychologist, but I see patients who have gone through like being offended or, and that's where I'm.
Okay.
But with the ones who get them.
So in your,
Like, I'm thinking of the, not a victim, but those who are.
Yeah. That's good. In your profession, you're an automatic, you have to automatically tell somebody about it. You have to report that, right? So you may hear sometimes the first time somebody says something happened. Does your job, that part of your job, does that affect the way that you're gonna be able to sit here if you're called on to serve in mystery? And would you say that you're not gonna be able to put that behind you in order to?
I will try, but I think it's
Yeah, try, I mean, it's hard, right? It's hard. The great thing about being an attorney is I don't have to suspend my bias. I don't, you know, the expert that you're from doesn't have to suspend bias. But we ask you, that's why it's so difficult and so important, and that's why it's the best system that we have. The best system in the world, is because we try to get the best fit for the trial. So in that instance, looking at all these people that we have, knowing we only need 12, is this a good fit for you? And is that because you are carrying in some kind of information from your employer?
Yes.
And you'll not be able to get over that. Thank you. Number 53.
question. When you say child, like how old are you talking about? Like under 18 or?
Well, let's talk about it this way. I can't go into facts of the case, obviously, right? But let's, what, is there an age? Is there an age that makes a difference, right? Is it like, if, okay, and do you have an age range that you think is more important?
Yes, I would say like any like children that are like under 15 is a difference from children that's 16 or older. This is a grandmother experience. So yeah, I'm going to answer that question when you're not like putting into terms like how young the child is.
Okay. If you
Ask your question first, and I'm gonna see it. Go ahead. It changed,
So yeah, so if you hear that there's a psychologist that makes a diagnosis of a pedophilic disorder, and someone asks what a pedophilic disorder is, that's a sexual attraction to prepubescent children. So if you hear that there's a diagnosis of pedophilic disorder, is that something that you're not going to be able to get through in order to sit on this jury?
Like,
Scientifically, it would be the development of secondary sex characteristics. So
yeah, that I wouldn't be able to get past because that's like a younger age, like infant or somebody who's like 5 years old, like that's different from like a 16-year-old.
so if you hear evidence about a child victim and evidence about a pedophilic disorder, are you automatically going to turn off and say enough is enough? That diagnosis alone by a psychologist, the person has a behavioral abnormality, the person is a sexual violent predator.
Let's just determine the yes or no, no. I'm not going to completely turn off.
Okay. Is it gonna affect your ability to listen to the facts?
Yes.
And how so?
Just like you said, like, age difference, like if there were a fact that they're, older than a certain age or something like that, that would determine my answer.
So would you, if you hear the facts come out of that state of child victims younger than 15, is that going to affect your ability to move forward and listen to the rest of the facts of the case and answer the question beyond reasonable doubt whether or not this person is a sexually violent predator?
No, I'm gonna object to commitment question.
Sustain,
Your Honor, that's a proper commitment question.
sustain.
Thank you.
You're welcome.
No, I don't think that would.
But, excuse me, so that everyone is aware, when I sustain an objection, what that means is next question. So don't
I'm
answer the
sorry.
question once I sustain it.
Okay, thank you.
No problem.
What was your number?
Oh, 52.
Does anybody have? How long is that?
28 minutes.
Yeah, great loads of time. Any other comments or questions regarding whether or not there's proof of this behavioral abnormality or any questions about the law before I move on? Number 17.
So basically, we're gonna try to say that like pedophilic disorder is like something wrong and like that it's like an actual like diagnosis, that someone's like diagnosed as a pedophile.
I can't like we said, we can't get into what's gonna happen in this case. I'm just saying hypothetically, if an expert comes up to the stand and the expert's a psychologist and the expert says that they diagnose this person with pedophilic disorder, is that gonna taint your ability to listen to the rest of the facts presented and follow the law? And it's tough, it's a tough question. Because, number 19, we had you.
Being used as an excuse.
Can you explain that?
Just because you say he's a pedophile, is that excuse him?
Well, I'm not,
Is that being used as an excuse?
no, I don't think so. Number 3?
I think that, what they're saying, or from my understanding, is if somebody comes up here, or the psychiatrist comes up here and says, this person is diagnosed as a pedophile, that's automatically saying he's guilty, and he's gonna always be guilty, right? Because that's what's wrong with him.
Yeah, that he's got this behavioral abnormality, that he, because of that diagnosis alone.
So that's why you're saying, okay, so you're asking us if we're exposed to that evidence that he's a pedophile, I'm automatically gonna say he's guilty, that's his diagnosis, and I'm not gonna change my mind.
Correct, but we're not talking about guilt or innocence. We're talking about whether or not you're gonna answer that question just based solely on hearing that evidence. And does that affect the way you're gonna?
No, it doesn't affect me, but I was thinking it might help answer their question.
Okay, number 24.
I'm curious about the expert witness and the requirement that they would have actually treated the individual. Because the question was raised about, looking at records. And I think it might change how I view the testimony if the person is only viewed the individual's records, but not actually interacted or treated.
Okay. I'll get you in a second. There was someone over here. Number 45.
The expert on that, is that saying that they have something physical that may be pedophile, or is it-
Well, I'm sure that would come up in the case, we just can't go into that here.
In reference to the records that you guys are talking about, would you happen to know the expert will go back records from 10 years ago, elementary, middle school, I'm just wondering if that's brought up.
I'm sure that will be addressed if we get, when we get in, if you're into that. In the box there, when we're into the trial, it's just something we can't go to here. Number 67, I think we have you, but yeah, what do you?
Yes, I was actually referring to the lady that I would like to know is an expert actually treating as a patient, or is just expert basing his knowledge on facts. Because unfortunately, I'm working in the field with insurances, kind of like you fight with insurances. And we do have a lot of experts in insurances which are providing incorrect information just because they are expert. It does not mean they know specifically this case. And that's my concern.
I understand that. Yeah. Number 69.
So I don't know if this relates, I just want to make sure I'm understanding things. So this is just like, you said answering a question, yes or no. Like we're not actually finding anyone guilty of pedophilic acts.
No.
It's just yes or no based on these facts, do they match these elements? Yes or no?
Correct. That's exactly right. Did everybody hear that? Number 41. Can you stand up for me? You said a few things earlier I wanted to kind of touch base on. Your brother is a psychologist?
Yes, sir.
Have you ever heard about this law before?
About which,
So, like chapter 841 of the Health and Safety Code?
well, my brother worked for almost 20 years in Utah, and he's only been working in Texas for the last 2 years. So,
Okay.
so I'm not familiar.
Okay. Thank you very much. Oh, and one other question for you. You had said something about an experience from a friend or family member that was pretty recent.
Yes,
Does that affect your ability to sit on this trial?
but will that affect my ability to look at the facts?
Yeah. Thank you very much. Has anyone ever heard of this case, this type of law? Yeah, I do want to go back through, and these are going to be the last questions that I ask. Unless anybody has any questions after that. But I want to go back through just to see if anybody's responses changed. Okay, and so we'll go row by row again. If your answers change to any of these questions, let me know. If it doesn't change, or if you can't remember it, I'll tell you what, just we'll do this. We'll go through it pretty quickly. You got the list. If you hear that a person has been convicted of more than one sexually violent offense and has served time for one, are you going to automatically come to the conclusion that the person is a sexually violent predator, or are you gonna be able to sift through those facts and listen to everything given to you from this box and follow instructions of the school? Right? On the first row, is anybody going to turn off after they hear that first part about repeat sexually violent offender? Second row? Number 13. This row here. Next row. The third row back there. Nobody's hands raised. The next row. 37, 40, 38. The next row after that, 45. And then that last row, 51, 52. This row here. Next row. 65. Second to last row, 71, and then the final row. No hands in the final row. Okay, number 22. So if you hear evidence, the state has to prove two things, right? Whether or not the person's a repeat sexually violent offender, and then whether or not the person has a behavioral element. If you hear evidence and you're convinced that the person has been convicted twice or committed multiple or committed more than one sexually violent offense, are you going to automatically answer the question, is he a sexually violent offender? Number 38. Same question, you sir. If you hear proof of, if you believe that there's evidence of more than one conviction for sexual violent offense, are you going to automatically answer the question about whether or not the person is a sexually violent predator? I'm sorry. No, you're gonna listen.
I would after multiple convictions. Question.
Okay, so if you, I'm kind of confused, so if you hear evidence of more than one sexually violent offense convictions,
Basically saying check.
check it, okay, thank you. All right, and then next question is going to be about the second part, right? The state has to prove two elements, whether or not there's a repeat sexual violence offender, and then whether or not the person suffers from behavioral abnormality. And that behavioral abnormality is defined as congenital or acquired condition affecting the person's emotional and volitional capacity, predisposes the person to commit a sexually violent offense to the extent the person commits it. Is there going to be anyone that answers that haven't gone over that a lot? Does anybody have any questions about that definition? No? And then we'll get down to the question that was asked earlier. If you hear evidence of child victims, this was asked earlier by the petitioner. If you hear evidence of child victims or pedophilic disorder, that alone, are you going to automatically answer that question? Is the person a sexually violent predator? First row. Second. This right here. 18, 19, 15. Second row. Third row. 34, 36. Next row. 37, 39, 40. Second to last row. And the final. 51, 54, 52, 53. We move over here. You guys remember the question? No. If there's evidence of a child victim or pedophilic disorder, we can automatically answer that question about whether or not the person's sexually violent. So would that be what all that you would need to say yes to that answer? Second row, 64. Third row, 66 and 65. Second to last row, 71, and then the last row. Number 15. So if you hear evidence of child victims or pedophilic disorder, you automatically are going to come to the conclusion that the person is a sexually violent predator.
If I keep hearing it, yes.
And if you did hear that, you wouldn't be able to listen to all the other facts presented. Okay, so when you look around and you see that there's 75 people here, you believe that your civil service would probably be better on a different jury. But I do have to ask you kind of a hard question. Whether or not that information alone is going to affect your ability to listen to the rest of the facts and data. Okay. Was it the diagnosis of pedophilic disorder or the child victims or both? Okay. Now you're saying that that's going to be difficult because it hits close out, right? So let's say we get into the middle of the trial and you do hear that. Is it going to have some effect on you? Or do you think it's going to have some effect on you? And if it does, is that going to turn you off? Number 53, standard form. If you hear evidence of child victims or pedophilic disorder, is that going to, are you going to answer the question whether or not the person is a sexually violent predator based solely on
The diagnosis, no, but like when it comes to the whole child victim thing, again, like, is there a legal term for what child victim?
I mean, there is, but we don't necessarily need to get into it. I mean, any child, I mean, we kind of talked about it earlier, and I think that you have kind of a view of where they are. And I just want to ask you, with that in your mind, with the potential of the evidence that can come in, if it's somebody that's under that threshold for you, is that going to turn you off? Are you going to automatically answer the question?
Judge, another improper commitment question based on Marty.
Your Honor, that goes directly to, because I'll get you the case. This. Yeah.
Should we approach?
Yeah, we
Is it
approach.
okay here?
Your time while you're up here.
I'm sorry.
I paused your time while
Okay.
you're up here.
So. Number 53. We can't get into kind of any facts or talk of ages. But all I'm asking is that if you hear evidence of child victims, is that going to cause you to turn off, answer the question yes, if you don't?
That alone, no. But if, like, if you said that, like, if I hear that there's a child victim, will any other facts of the case turn me off, right? If the fact that the child was below a certain age comes into the question, then yes.
Okay, and if you hear evidence of a diagnosis of pedophilic disorder, would that affect your ability to listen to the facts, the rest of the facts of the case, and answer the question?
No.
Okay. Thank you. And then number 64. Number 64. If you hear evidence of child victims, are you automatically going to jump to the answer yes, if the person's a sexually violent predator? Thank you. And right now, what I want to do is I want to see cards of people that have not said anything. Is there anyone in here who has not said anything?
Right here. There, I said your words.
Number 6. Okay. Have you heard everything?
I heard everything.
You're clear on everything?
Yeah.
Did you have any questions?
Not any question that I have to hear everything.
Yeah. Okay. Perfect.
Come up with an answer.
Perfect.
My opinion.
That's what we're looking for. Number 14. Did you were you able to hear everything? Did you have any questions about anything? Okay. Who else has not spoken? 21. Do you have any questions? Number 21. What do you do for a living? Who else has not said anything? Number 57. Have you been able to hear everything? Do you have any questions about anything? Okay, and what do you do for a living?
Both sides. I'm in banking. I work in the credit card department, doing retail credit cards.
Number 58. What about have you heard everything?
Yes, I'm curious. It's a bunch of criminal stuff that's going on, but it's civil. It's a civil case, right?
Well, correct. It's a civil case. There are some little criminal undertones beyond reasonable doubt. It can get a little confusing, but yeah. Did you have any other questions about it?
No.
And what do you do for a living?
I'm a deputy sheriff.
Is your role as a deputy sheriff put you in contact with people that have been accused of certain crimes?
It can, I mean, yes.
Does that work? Does that affect, does that create a kind of understanding or thought regarding, persons that may be accused of sexual offense?
Repeat that, I can't hear you.
Still gonna listen to all the facts that are good.
Thank you. Thank you. Okay, 74, you haven't spoken? Can you stand up on it? Have you been able to hear everything?
Everything.
Okay. You have any questions about anything? And what do you do for a living?
I'm a long-term substitute teacher.
How long have you done that?
5 years ago, after doing 4 years, special ed teacher, and I started 7 days.
Okay.
For about 6 years. 6 years.
You were in special education?
Yes.
By teaching in special education, do you have any thoughts about, maybe abnormal, not behavioral abnormality, but abnormal behavior in the classroom? So, and I'm assuming that you probably go to like ARDs or did go to ARD meetings and maybe did like a BIP, behavioral intervention plan, something like that. Does that affect your ability to look at this case individually? Thank you. Okay, was that everybody here? 63? Okay. Do you have any questions about anything?
No.
And what do you do for a living?
I'm also a teacher.
Okay. Thank you very much. There were some people that had their number 55, stand up for me, sir. Did you have any questions about anything?
No, sir.
Okay, and what do you do for a living?
Facilities director for charter school.
Okay. Thank you very much. Is there anyone on this? Oh, okay, 44?
I work at a store for a non-profit organization.
I'm sorry, can you say that again?
I work at a store for a non-profit children organization.
Okay. Thank you very much. A few others here. 33? Do you have, you haven't spoken at all?
No.
Okay. What do you do for a living? Okay. And I believe we talked to you before, so. And then the next one, 32. Have you been able to hear everything?
Yes, sir.
You have any questions?
Yes.
Okay, what do you do for a living?
Work in manufacturing.
1 minute.
Thank you. Number 1. What do you do for a living?
I'm a college student and I work in fast food.
Okay. Thank you very much. All right. Okay. All right, guys. Other than that, I don't think I have any time. So thank you very much. And we'll talk to you guys soon.
All right, everyone, we're gonna take a short break. I'm gonna let you all wait outside, and we're gonna come back at 12:30. And at that time, we will know who's going to be seated on the jury. So everyone, please rise for the jury. Make sure you're back at 12:30 though. Yes. All right, we are back on the record. Petitioner responded, have you both had a chance to review or agree on jury strikes?
Yes, Your Honor.
Yes, Your Honor.
And off the record, my understanding, the following strikes are agreed to. Number 4, number 11, 13, 15, 16, 18, 19, 22, 34, 36, 37, 38, 39, 40, 43, 45, 51, 52, 54, 55, 64, 65, 66, 69, and 70. Is that correct? Petitioners?
I have 70 and 71, but I do not have 69.
I have 70 and 71.
Oh, sorry. Okay, so not 69, but 70 and 71.
Yes, Your Honor.
Yes, Your Honor.
All right, so any other corrections? Petitioners?
Not from petitioner, Your Honor.
Respondent?
No, Your Honor.
And are there any other disagreements with regards to the list that includes the agreed strikes?
No, Your Honor.
Let me check one thing, Your Honor. No, Your Honor.
All right, then Brenna will go off the record. All right, so what I'll do All right, so everyone, I want to thank you for your service. You should all have excuses. So you can take those with you. The numbers, sometimes people want to keep those numbers as a souvenir. Please do not take those numbers. So whoever put it in their backpack, maybe, please leave those. Those are very expensive. If only you knew how much time and effort it took to get those numbers. So if you can leave those numbers behind and not take them as a souvenir, take your excuse as a souvenir. So again, thank you all for your service. We cannot have jury trials without jurors. So it is appreciated. And after I announce who will be in the jury box, everyone will have a decision to make. You can probably go back downstairs and maybe get selected for another jury. If you would like to, no, let that marinate. Don't immediately answer that question. Let it marinate. So the names that I call, if you will please take a seat in the jury box. Kaija Velarde, Ruby Martinez Barrier, Benito Juarez, Rosario Gomez, Jaime Sanchez, Victoria Clark, Alam Younes, Jesse Sanchez, Martin Gomez, Fabian Maltos, Chad Mueller, Brent Leatherman. The two alternates are Daniel Sherwood and Angelica Mancinas. I want to do my number count. All right, everyone else. We're going to get up slowly. We're not gonna run. We're gonna leave the expensive numbers that identified you. And the stickers, those are stickers now. They used to be pin on, so we've gone low tech with the stickers now. The stickers, you can also keep those as souvenirs for your time spent in the 187. I just want to let, yes.
Is there any additional excuse forms? Yeah. Because some of them are not available.
We have, there's some people that got 2 of them.
If you have 2, you only need 1.
Thank you.
Thank you. Make sure you only take 1, everyone. I'm sorry?
I don't want to get in trouble.
Okay. All right, so the deputy is at the back. Do not rush her. You've all had a chance to think, would you like to go back downstairs to be placed in on another panel? All right, so here's the other thing. There may be payment, I think. It's been 2 years since we've done jury trials, but what you can do with the payment or fee that you were going to receive for today, you can actually donate it downstairs in the jury room. They have different organizations that use those funds for whatever they need. Sometimes it's for bedding and different things. So you can consider donating that, or, lunch is on us. All right, everyone, you are excused except for people in the box. Yes.
What about parking? They said they were gonna stamp more things or something.
That's downstairs in the jury room.
Oh.
So if you go to the basement and show them that you're done, they'll stamp it. Thank you. Thank you for coming. All right, everyone, I'm going to give you your instructions so that I can make sure that you are out in time for your late lunch. You may be seated. So we're going to start tomorrow at 9 a.m. We can't start at 9 a.m. unless everyone is here at 9 a.m. When you come to the courtroom, you're not going to come to this courtroom. The deputy will show you to the jury room, and that's where you'll be placed. You have not heard any evidence in this case whatsoever, because none has been presented to you as of yet. Do not discuss anything about this trial with anyone. Does everyone understand?
Yes.
So the temperature in this courtroom sometimes is extremely cold, sometimes extremely hot, you never know. So I always tell jurors it's best to wear a jacket. You can always remove your jacket, but if you come in freezing because somebody's done something with the thermostat, there's really nothing I can do about it. There's a thermostat that's over there that's just been placed there, but if I touch it and change dials, it does nothing. So I think that's just, for us to try to do something. You are allowed to bring water or some sort of drink if you want to drink while you're listening. Sometimes we get thirsty. I know I get thirsty a lot because of my allergy medicine. So you can bring that. Just make sure it has a top or something on it because we get a lot of spills and that doesn't look so great. If ever you need a break, just raise your hand. Either I will see you or Brenna or the deputy of one of the parties will see you and they'll let me know. You may see sometimes people coming to the side door for me. That's dealing with other matters, not something about this case, because I do have a docket that's happening, even though we're in trial. So I may have to sign documents. Sometimes you may see an officer coming through the side door. Again, that has absolutely nothing to do with this case. Does everyone understand?
Yes.
All right. So remember to raise your hand. If you want to bring some breakfast or lunch in the morning, there is a refrigerator in the jury room, so you can keep it in there. All right. Any questions about anything? All right. I try to make sure that we break every day at 4:30 p.m. The reason why I do that is because of rush hour traffic at 5. I still stay here late, but I find that sometimes with jurors, you have places that you want to make sure you're on time, and rush hour traffic, and plus all the construction just ruins that. So we'll be resting at 4:30 unless there is testimony and someone's maybe in the middle of testimony, then we may go past the time that I'm telling you. I anticipate, or I've been told that this trial could be completed by Friday. We shall see. Things sometimes take a life of their own. All right, any questions from any of you? Yes.
Dress attire?
Oh, you all are dressed perfectly today. I always just tell people, no t-shirts, please. But otherwise, you all are dressed fabulous today. Any other questions? Yes.
Yeah, I mean, the English is for me is like the second language. There's a lot of words I didn't understand.
Okay. All right. If there's something you can't hear, no, I'm adding that as a segue into this. If there's something that you're not hearing or you don't understand, just raise your hand and let us know. Okay. And I'm sorry, what was your name, sir? And your first name?
Yeah, the first name Allah, last name John, Y-O-U-N.
Oh, okay. All right, thank you. It's easier for me to find you by your last name. Is there anything else from? Yes.
I have a question.
I heard the name Martin Gomez. And that's someone I know from high school, but I don't know if that's Martin. People live in high school? No.
Hey, we thought it was gonna be a high school reunion. All right, anything else? Well, with that being said, I will see y'all tomorrow. We're gonna start promptly at 9 a.m.
Yes, follow me, people. Don't forget the number 2.